Is breaking and entering a felony? Breaking and entering evokes images of masked intruders smashing windows, yet New York law does not recognize it as a standalone crime. Instead, conduct that people describe this way falls under trespass or burglary statutes. To convict, prosecutors must show that a person entered or remained in a building without permission and intended to commit a crime inside. Physical breaking is unnecessary. Reaching through an open window or gaining entry by deception can satisfy the entry element. Because these cases carry serious consequences, consulting a criminal defense lawyer early is vital. Seeking guidance from a law firm at the outset can help protect your rights. Trespass involves knowingly entering or staying on property without the owner's consent and may be charged as a violation or a misdemeanor. Burglary always requires an unlawful entry plus the intent to commit another offense and is treated as a felony. New York law further classifies trespass and burglary into degrees that reflect the seriousness of the conduct. Factors include whether the location is a dwelling, whether the intruder carried a weapon or displayed something that looked like a firearm, and whether anyone was injured. These elements determine whether the charge is a lower-level trespass or a violent felony. Punishments vary widely. Criminal trespass can range from a minor violation with up to 15 days in jail to a Class D felony when someone enters a building while armed with a deadly weapon. Burglary in the third degree is a Class D felony involving unlawful entry into any building with intent to commit a crime. The second and first degrees involve dwellings or aggravating factors and carry harsher sentences. A conviction for third-degree burglary can result in up to 7 years in prison, second degree up to 15 years and first degree up to 25 years. Courts may also impose fines, restitution, probation and post-release supervision. Even a misdemeanor trespass conviction can leave a lasting criminal record that makes it harder to find work or housing, pursue education or obtain professional licenses and may affect immigration status. Defenses focus on authorization and intent. If the property owner gave you permission to enter or you had a legal right to be there, that defeats the unlawful entry element. A mistake of fact, for example, believing the dwelling was your own, shows you lacked criminal intent. Demonstrating ownership or lease agreement achieves the same purpose. When the state's evidence about how you entered is weak or inconsistent, a defense attorney can argue that prosecutors have not met their burden. Defendants may also claim duress if someone forced them to enter or simply argue that they had no plan to commit another crime inside. Youthful offenders face different treatment. When 16 or 17-year-olds are accused of burglary or criminal trespass, their cases start in a youth part before a judge trained in family matters, and many cases are transferred to family court under New York's Raise the Age system. Youthful offender status may replace a conviction and is available for some defendants, but it is discretionary and limited for armed felonies. A legal advocate can petition for transfer and present evidence to support leniency. So is breaking and entering a felony? New York law does not use that phrase, but the underlying conduct can result in misdemeanor trespass charges or felony burglary charges depending on intent and circumstances. Unlawfully entering a building without any plan to commit a further offense may be a lower-level trespass, while entering with a criminal purpose constitutes burglary, a felony. Whether the location is a dwelling and whether weapons or injuries are involved determine how severe the charge is. Given the serious consequences of a conviction, early consultation with a lawyer is critical. At the law offices of Jason Bassett, P.C., clients receive representation from an attorney with more than 2 decades of experience defending people accused of burglary, trespass, and related offenses. Whether you need help challenging charges, seeking to transfer a youth's case to family court, or negotiating for youthful offender treatment, this law firm provides focused advocacy. To get advice tailored to your circumstances, contact the law offices of Jason Bassett, P.C., at 320 Carleton Avenue, number 4200, Central Islip, New York, 11722, United States, by calling 631-259-6060.